Not just attacking healthcare fraud here in the United States of America. Our adversaries are taking advantages of the loopholes and the lack of enforcement by the prior administration to fleece our senior citizens of their valuable life savings. For these perpetrators to know is that there is no safe haven. We will give you no sanctuary. In the month of July, the FBI executed almost 30 foreign transfers of custody. If anyone in the world has information on these perpetrators, 1-800-CALL-FBI, 1-800-CALL-FBI. Our best partners are those in law enforcement. The dynamic threat landscape of the drug trafficking world unfortunately has permeated into not just deploying these lethal doses of fentanyl and other narcotics that are killing Americans at a record rate. You heard from the Attorney General and the
Kash Patel just melted down in real time as a Supreme Court judge tore into him for lying under oath, and the entire federal law enforcement apparatus is still shaking from the fallout. The moment the judge finished reading the actual court records out loud and then looked Patel dead in the eye and said the testimony does not match a single page of the official file, the color drained from the FBI director's face. What followed was not a composed institutional defense. It was a visible collapse. Patel's voice cracked. His hands started moving in short, sharp gestures. He kept repeating that he was only speaking to his own actions, while the judge kept citing line after line of sworn statements that the documents themselves contradicted. The courtroom went dead quiet except for the sound of the court reporter's keys and the low murmur from the gallery when the judge finally said the words that will define this chapter. The sworn claims are false on their face. This was not a routine evidentiary hearing. This was a federal judge of the highest order placing the director of the Federal Bureau of Investigation on the record for making statements under oath that the underlying paperwork simply does not support. Patel had told the court that certain Epstein-related files could not be...
The DEA administrator, and you'll hear from our team, the record successes we've had from getting the Chinese to delist the precursors that were dumping this poison to the Mexican cartels and manufacturing it down south of the border and pumping it here. You've heard that there's been an over 20% reduction in opiate overdose deaths, 22% specifically related to fentanyl. That is a monumental achievement thanks to President Trump's initiative and direction and push to manhunt federal foreign terrorist organizations wherever they exist and whatever umbrella they choose to operate under. The FBI is here today to announce 3 of individuals who are being elevated to our most wanted perpetrators around the world, not for drug trafficking, but for fraud. You've seen what the president and the vice president have done under their anti-fraud task force. And thanks to the great leadership of Attorney General Blanche, we are not just attacking healthcare fraud here in the United States of America. Our adversaries are taking advantages of the loopholes and the lack of enforcement by the prior administration to fleece our senior citizens of their valuable life savings. And they are doing it in a sophisticated manner. And it takes a whole-of-government approach, which you see here represented today, led by the Attorney General, to execute on that mission to safeguard our senior citizens. These individuals, pursuant to the New York Field Office's investigation that began a few years ago, started call centers down south and across the world. The funds they utilized and they scammed out of these call centers from senior citizens from across America totaled over $400 million. They duped our seniors using email, telephone, text message, and phishing campaigns into subscribing to a timeshare project that they falsely stood up and falsely delivered promises that our seniors would be able to enjoy their lives and their vacations, only to have that money seized from them and that vacation and their retirements deprived from them. This FBI is laser focused with our interagency partners, not just on these foreign terrorist organizations for dumping these illicit narcotics into our country, but keeping up with the dynamic threat that they pose on the fraud that they have now unleashed on our country. But thanks to this team and thanks to Attorney General Branch and thanks to the President of the United States, we are now chasing them down around the world, as Administrator Cole pointed out. This is truly remarkable work that is a partnership effort. It takes every single agency you see up here today, and most importantly, it takes a president who is willing to safeguard Americans and put America first. And President Trump has done just that. One of the most important things for these perpetrators to know is that there is no safe haven. We will give you no sanctuary. In the month of July, the FBI executed almost 30 foreign transfers of custody in over 15 separate countries for drug traffickers, terrorists, murderers, and rapists. So what I'm here to tell you today, for all these individuals that are on the run right now, you will not be on the run for long. We will hunt you down in every corner of the planet, and we will return you here to face American justice. The numbers that we at the FBI and our partners are returning to America to face justice from overseas is a record-breaking number. It is a direct result of President Trump's relationships with foreign governments that allow us to work in spaces we were never permitted to work before. And that is why we are delivering these historic results, returning these individuals to America for justice. And most importantly, once they are in our justice system, we have seized these funds.
Released because of existing protective orders and sealed directives. The judge pulled the docket. No such blanket orders existed. Patel had insisted he played no role in the recent wave of terminations of agents and analysts who had worked the Mar-a-Lago classified documents investigation. The personnel records and internal communications told a different story. Patel claimed he had never been difficult to reach and that his security detail never had trouble locating him. Multiple contemporaneous reports and sworn statements from the detail itself contradicted that assertion. Each time the judge placed the document next to the testimony, the gap grew wider until the only remaining question was how long the director could keep insisting the contradictions did not exist. The meltdown itself unfolded in stages. First came the flat denials, then the careful parsing of language, then the sudden insistence that everyone is allowed to make allegations, then the visible irritation when the judge refused to accept the parsing and simply read the plain text of the orders that Patel had claimed prevented compliance. By the time the judge asked whether Patel understood that false statements under oath in federal court carry criminal consequences, the director's posture had changed completely. Shoulders forward, jaw tight, answers shorter. The controlled political operative who had sailed through confirmation hearings promising zero politicization and zero retribution was gone. In his place sat a man watching the ground shift under the very authority he had claimed for months. The firings that form the backdrop to this confrontation are not abstract. At least a dozen agents, analysts, and support staff who had been assigned to the classified documents matter or related January 6th investigations were removed in a compressed window. The official line from the Bureau has been that each separation rested on failure to meet standards or uphold the constitutional oath. The timing undercuts that explanation. The same week Patel faced the judge over document release, claims the personnel actions accelerated. Whistleblower accounts that reached the Senate Judiciary. Committee described direct communications about the need to clear out personnel who had touched Trump-related cases. When Senator Durbin pressed Patel on those accounts during an earlier hearing, the director denied knowledge of any purge directed by Stephen Miller or anyone else.
And we are going to get them back to the senior citizens that were fleeced of their life savings and their retirements. That is the mission of law enforcement. That is the collective mission of the interagency partnerships you see here today. I'm thankful to be able to stand shoulder to shoulder with these agencies, our prosecutors, the Department of Justice, and this White House, laser focused and primary importance on protecting our most vulnerable, our kids, and our elderly. And you're seeing that done here today. And this FBI, along with our interagency partners, will not rest. If anyone in the world has information on these perpetrators, 1-800-CALL-FBI, 1-800-CALL-FBI. Our best partners are those in law enforcement, but as I've always said, our truly best partners are the American citizens around the world who've got eyes and ears everywhere. We want to hear from you. Thank you.
The president has publicly criticized U.S. Attorney Jeanine Pirro for her decision to drop the Reflecting Pool case. Do you agree with the move to dismiss the charges against David Hearn?
So I think that U.S. Attorney Pirro, over the past year and a half that she's been there, year plus, has led an unprecedented effort to literally just turn this city on its head and to be a safe place for all of us to live and eat. And so I've watched the communication that President Trump, who has every right to be extraordinarily frustrated with damage done to our national monuments and in this city and elsewhere, but Judge Pirro is doing a great job, and our city, Washington D.C., is a lot safer in no small part to her effort and the prosecutor's efforts that she works with.
To follow up on that question, were you aware that U.S. Attorney Pirro was going to drop the charges? against David Hearn? And if so, did you approve of that decision?
So I'm not going to talk about internal discussions. I don't approve or disapprove decisions that our U.S. attorneys make in a general matter, but I'm not going to talk about what we knew about the case or didn't know about the case. I mean, we have a great relationship. By we, I mean Maine Justice and U.S. Attorney Pirro in a lot of different cases that we work on. So again, I don't want the message to be because President Trump expressed appropriate frustration at the damage done to the reflecting pool, that Judge Pirro is not, and not only Judge Pirro, her prosecutors are not working every day to combat violent crime and to make this city safe. So, yeah. Go ahead.
One on topic, one off topic. Is that okay?
All the top questions have been off topic.
Okay, so I just wanted to ask about the current case that the current case you guys are talking about. The DEA director briefly mentioned, I'm paraphrasing, something to the effect of politicians, elected leaders, the U.S. will stop at nothing to go after these suspects. You also mentioned elected leaders potentially protecting people named in this indictment. Does the U.S. at this point have any thoughts or considerations that there could be foreign governments, foreign elected leaders who are protecting any of the named suspects that were just brought up today, potentially at all? And does the U.S. Believe that it would be necessary potentially to charge any foreign elected leaders if that was happening in this case?
Do you want to answer initially, then I can follow up?
Sure.
Go ahead.
So I think what's important here, in my remarks, this is about Americans first and America first. There are far too many Americans that are dying at the hands of the cartels who have been designated a foreign terrorist. On a side note, each day when I walk into DEA headquarters, I walk past the faces of fentanyl. There are 7,000 kids. Their pictures are on our
records now being examined suggest knowledge was not the issue. Coordination was. What makes the Supreme Court judge's intervention especially damaging is the institutional weight it carries. Lower court judges can be dismissed as activists or partisans. A justice of the highest court speaking on the record about the mismatch between sworn testimony and actual dockets cannot be waved away. The statement was clinical. It did not traffic in political rhetoric. It simply laid the testimony next to the paper and declared the two irreconcilable. That declaration lands differently inside the Bureau. Career agents who already watched colleagues removed for working the document's case now see their director publicly corrected by the Supreme Court itself. Morale does not recover from that kind of public accounting. Trust in the chain of command erodes when the person at the top is shown to have offered the court a version of events the documents refuse to support. The legal exposure is concrete. Perjury in federal court is a felony. Criminal contempt is available when a party willfully misrepresents the state of court orders to avoid compliance. The judge did not merely express disappointment. The judge set a hard deadline for production of the materials Patel had claimed were barred and warned that failure to meet it would trigger referral. 5-year exposure on the perjury side, additional exposure on the contempt side. Loss of law license, end of federal career. Those are not theoretical risks. They are the ordinary consequences that attach when a federal officer's sworn statements collapse under documentary review. The fact that the officer in question happens to run the FBI does not create an exemption. It raises the stakes. Patel's confirmation commitments are now part of the public record that the judge's findings contradict. He told Senator Coons there would be no politicization and no retributive actions. He assured Senator Blumenthal that all FBI employees would be protected against political retribution. Under oath in the later proceeding, he maintained that every termination rested solely on performance and oath. The personnel actions targeting agents who investigated the former president's handling of classified materials sit uneasily next to those assurances. When the same director is then caught telling a court that protective orders exist, which the docket shows do not exist, the pattern stops looking like coincidence and starts looking like a single strategy.
Director Kash Patel and a whistleblower's allegations about how he's using FBI planes. Joining us, MS Now senior investigative reporter Carol Lenig. So, Carol, what do you got?
A whistleblower has reported to the Senate Judiciary Committee Democratic ranking member Dick Durbin that FBI Director Kash Patel's use of his jet, the government jet, the FBI jet, has harmed actual investigations. Katie, I want to separate one thing, which is to say one of the allegations here is something that we at MS Now, my colleague Ken Delaney and I, have been reporting on for a while, working on this behind the scenes, and then the whistleblower comes forward to Congress and basically affirms a lot of our reporting, although there are new details here. The whistleblower says that in December of 2025, when there was a mass shooting at Brown University, Kash Patel was on his government FBI director jet in Florida, we are told, and that there was only one other available jet. But Patel had ordered it to be put on standby for another team. And that meant that during this mass shooting, an evidence review team based in the Washington, Virginia area that would normally immediately respond to a major crisis, a major crime scene like this, was delayed. They could not use the plane. And instead, they drove through the night of the 13th and the early morning of the 14th to get to Providence, Rhode Island from Virginia. They happened to also drive through a snowstorm to get there, but they were significantly delayed, according to this whistleblower's account. And by the way, also according to multiple sources that spoke to Ken and to me.
You guys have also been reporting on the various trips that he's taken. There's the Olympics just the other day where he was seen shotgunning a beer with the U.S. men's hockey team. But there's also been a number of trips to Nashville to see his girlfriend and the like. How has this agency responded to that, especially, as you very well know, Carol, Kash Patel himself was critical of Christopher Wray for using an FBI jet when he was FBI director?
That's right. When he was basically just a Trump ally, hoping Trump would be reelected for a second term, Kash Patel gave an interview in which he said they should ground Chris Wray's director jet and said that it cost $15,000 every time it took off, which is not far off, actually, in dollar amount. The rules require the FBI director to travel on this jet so that in a time of crisis, he can quickly be returned to secure communications or to Washington to manage said crisis. The issue inside, and this goes to your first question, Katie, the issue is that inside the FBI, agents and operatives are growing increasingly frustrated and, frankly, disdainful of how the director is choosing to use the jet. Whether it's for personal or for business reasons, his choices of where to fly, when,
executed across personnel and litigation tracks. The Epstein file dimension adds another layer of institutional damage. Patel's insistence that court orders blocked release was not a minor scheduling disagreement. It was a representation made under oath about the legal constraints on the Bureau's ability to respond to congressional and judicial demands. When the judge examined the actual orders and found no such constraints, the representation became evidence of something else. Either the director did not know the state of the dockets he was describing, or he described them inaccurately while under oath. Neither explanation is compatible with the role. The FBI director is supposed to be the person who knows precisely what the records say and what the court has ordered. Offering a version that the records refute undermines every subsequent claim the Bureau makes about its own files. Inside the building, the effect is corrosive. Agents who still have active cases involving politically sensitive subjects now calculate the personal cost of thoroughness. If the director can be shown to have misstated the existence of court orders and can still remain in the chair, the signal is clear: political. Protection travels upward and consequence travels downward. That signal does not stay contained. It spreads through every field office. It reaches every joint terrorism task force. It reaches every public corruption squad. The Bureau's legitimacy has always rested on the perception that its investigations are driven by evidence rather than by the identity of the subject. When the person at the top is publicly corrected by a Supreme Court judge for statements that protected a particular political figure, that perception takes a permanent hit. The broader political calendar makes the timing even more consequential. Midterm campaigns are already underway. Voters who still believe law enforcement should operate independently of the White House now have a concrete episode to point to. The director who promised neutrality is the same director who lost a documentary confrontation with a Supreme Court judge over the accuracy of his sworn claims. The agents who worked the classified documents investigation are the same agents who were removed in the weeks surrounding that confrontation. Opposition candidates do not need to invent a narrative. The timeline supplies it. Historical comparisons only sharpen the damage. Past FBI
Patel live his life using taxpayer funds, allegedly. But when you think about, compared to the first term, right, when there was an embarrassing headline, usually that person was kind of ixnayed very quickly. Kash Patel has been able to hold on largely, according to Jackie, because of his ability to deal with 2020 and act on what Donald Trump wants when it comes to 2020. She right?
So I don't actually have any reporting on this latest incident, but what we have in the book is checks out with what you're describing, which is that particularly last summer, President Trump was complaining quite a lot about Kash Patel. And what he didn't like was he was calling him flashy Kash. He didn't like to see him basically going to these UFC fights and flying around on the jets and just sort of embracing the lifestyle. And what Trump really wanted was to see him, quote unquote, do his job. Of course, in Trump's mind, that has a very particular meaning. And one thing that he didn't seem to grasp was that Kash Patel couldn't personally just imprison all of Trump's various enemies. So Trump was very frustrated with the Justice Department in general, with Kash Patel, with Pam Bondi. It was largely over what he saw as this slow pace of prosecutions with people like James Comey, Letitia James, go down the list of John Brennan, people that Trump wants to see behind bars. So I actually haven't got any reporting on the latest with that, but it got so bad late last year that both Maggie and I were talking to sources at a senior level of the administration who thought that it could be imminent that Trump would make a change at the top of the FBI, but obviously he hasn't. And I just don't know what the latest situation is with him.
I was going to try to ask some more forward-looking highbrow question, Maggie, but because you brought her up, can we talk about the Natalie Harper of it all? I mean, obviously, presidents across the board always find people, they have their body person or a fixer that they bring in from a past life who is able to demonstrate this extreme level of loyalty and allegiance to them and their and everything about them. But Natalie Harper has seemed to taken things to the next level, even more than someone like Hope Hicks or Michael Cohen, so to speak. Can you describe their relationship and whether Natalie is viewed as a positive force or a negative force by the people around her in the White House?
So during the campaign, and we describe this in the book, she became ever present. She would join him on the golf course when he was golfing, in the interregnum period, even before the campaign, literally sometimes running on foot behind his golf cart.
With a printer?
I think just running. But yes, she was known as the human printer because she often, in later iterations, would carry a battery-charged portable printer, and she would print out, a healthy supply of positive news that he wanted to see or she thought he would want to see. He considers her very loyal. He will say to advisors, you'll all go off and make money. We describe this in the book. She'll never leave me. But she was also a source of concern during the campaign because, among other things, she was leaving very personal notes in his private spaces, one of which said, "You are all that matters to me." Others talked about, sort of wanting to have a longer conversation throughout the day and not talk about work. The Secret Service was concerned about this. Nonetheless, as I said, he values loyalty.
Directors have faced congressional criticism and internal dissent. None in modern memory have been told on the record by a Supreme Court judge that their sworn description of court orders did not match the orders themselves. The institutional memory of the Bureau includes the lessons of earlier politicization scandals. Those lessons are being rewritten in real time by the current leadership's choices. When the next generation of agents looks back at this period, they will see a director who promised one standard at confirmation and delivered another under oath when the records were placed in front of him. Patel's attempts to recover after the judge's statement only compounded the problem. The insistence that he was only speaking to his own actions and that others are free to make allegations lands as evasion once the documents are in the open. The claim that every termination rested on standards and oath is undercut by the concentration of those terminations among personnel who had touched Trump-related matters. The assertion that he was always reachable and that his detail never struggled to locate him is contradicted by the very reports the judge referenced. Each defensive move opened a new gap rather than closing the old ones. The judge's language was careful and therefore more devastating. There was no raised voice. There was no partisan framing. There was only the placement of testimony next to paper and the declaration that the two could not be reconciled. That method leaves no room for the usual political counterattack. Accusations of activism or bias lose force when the critique is limited to the accuracy of sworn statements about the contents of the court's own files. The record is the record. The testimony either matches it or it does not. In this instance, the match failed. What happens next will test every remaining institutional guardrail. The deadline for document production is fixed. Noncompliance triggers the contempt machinery. Our referral for perjury is available if the Department of Justice chooses to act. Congressional committees already possess whistleblower accounts that track the same timeline. The combination of a Supreme Court judge's on-record finding and the personnel actions that preceded it creates a factual foundation that does not require additional invention. The only remaining variables are whether prosecutors move and whether the political system decides that an FBI director who lost a documentary confrontation.
And he values the fact that she is willing to constantly provide, positive information. It is literally sort of the sun is always shining. There are other people like that in Trump's orbit, and we talk about this in the book too. Boris Epstein, for instance, who, is known in Trump's world, he's Trump's top legal advisor, known as the good news guy. Trump has made clear to people that he likes having someone who will essentially say, everything's going to be okay, everything's going to be fine. In Natalie Harp's case, she's also a conduit for information. She is a way for people to bypass the official chain. She is a way to get, texts to him that people want to have him see. And that is its own level of power. And she is in almost every single, really, I'm not kidding, almost every single meeting. She is sitting, and you can see her in pictures of almost every public event that he does. She's on the side of the Oval Office, by the door, nearest to the exit to the colonnade. That is the role she plays, and that is the role I expect she will continue to.
Jonathan, I want to switch gears just a little bit and bring up the story that's come out of Houston. Man killed by federal agent in Houston was not the target of ICE search. Federal immigration agents who killed a man during a traffic stop in Houston on Tuesday had been searching for a different person, according to a Department of Homeland Security spokeswoman. I bring this up because this is the first shooting we know of since the brouhaha over the shooting of Alex Preddy, first Renee Good and then Alex Preddy in Minneapolis, which led to a lot of changes at DHS, a lot of changes in personnel, and a lot of changes in tactics, not as in your face. But I just wonder, do headlines like these cause the president, cause the administration to decide, maybe we should change course? Or do headlines like these not have any impact in the administration, and particularly Stephen Miller decide, we're going to keep moving forward on something that is disruptive, to say the least?
They definitely have an impact, but this story is a good reminder that actually, despite public perception, they haven't turned off the switch on the mass deportation, on their efforts to remove people from the interior of the country, that they're just doing it in a less theatrical way. That's really the only thing that's changed. Is before you had, Kristi Noem riding around on a horse with a camera crew, Greg Bovino with his big olive coat, which we have in the book a senior White House person called his SS coat. There's less of the performative stuff, but the deportation operation is still continuing. Look, there's a division of opinion within the administration, and this is something we get into in the book. I think it's important for people to understand. Renee Good gets killed. Alex Preddy gets killed. This is in January, and there's huge public outcry. A few days after Alex Preddy gets killed, the vice president walks into Susie Wiles's office for a senior staff meeting, and he says, we should invoke the Insurrection Act, that we need to suppress these left-wing protesters. He says they're all paid activists. There's not any evidence that Renee Good or Alex Preddy were paid activists, but that's what he was saying. And so then a debate ensues. And one of the top lawyers in the White House, Will Scharf, says essentially that the conditions do not warrant such an extreme action as to...
Under oath can remain in the post. The meltdown did not arrive as a single outburst. It arrived in layers. First, the rapid blinking. Then the short, clipped answers that grew shorter still. Then the sudden shift to the claim that he was only speaking to his own actions, while everyone else remained free to make allegations. The judge refused the pivot. The records were the records. The testimony either tracked them or it did not. In this instance, it did not. The gallery watched a man who had spent months projecting absolute control lose that control in real time under the fluorescent lights of a federal courtroom. What the judge placed on the record was not interpretive disagreement. It was documentary contradiction. Patel had told the court that existing orders prevented release of certain files connected to the Epstein investigation. The docket showed no such orders. He had insisted under oath that he played no part in the terminations of agents and analysts assigned to Trump-related matters. Internal communications and separation paperwork told a different sequence. He had denied any difficulty in being reached by his security detail or by senior staff. Contemporaneous reports from the detail? Its self-described repeated delays and unanswered attempts during critical windows. Each denial met the same fate. The paper contradicted it. The agents removed in the weeks surrounding this confrontation had worked the Mar-a-Lago documents case or related January 6th investigations. Their names appeared on the same internal lists that later surfaced in whistleblower accounts reaching the Senate. The official explanation remained performance and oath. The concentration of those removals among personnel who had touched the former president's legal exposure made the explanation difficult to sustain once the timeline was laid out. The same director who faced the Supreme Court judge over false descriptions of court orders was the same director whose tenure coincided with the rapid exit of the investigators who had examined those documents. Inside the Bureau, the effect registered immediately. Field supervisors began receiving quiet questions from their teams about the safety of thorough work on any file that carried political weight. Joint terrorism task forces noted a measurable drop.
Appeared before Congress to specifically discuss the upcoming budget for the FBI along with other law enforcement agencies. And so he was met with near universal praise from Republicans, with the New York Times reporting that Senator Katie Britt thanked him effusively for the Bureau's work in her home state of Alabama. Now, guys, let me just pause for a second. Kash Patel's a disaster, and no one has been able to persuade me otherwise. But putting him aside, the FBI is a giant agency that does all sorts of work. And some of that work, even under the Trump administration, has been good work, right? They've been finding and disbanding criminal enterprises and entities. And so when Britt says that about the FBI, it's not necessarily a lie. The FBI might have done something in the state of Alabama that actually did benefit the people of Alabama. So I just want you to be aware of that. Now, when it comes to Kash Patel, his conduct and his investigations, that's where we're starting to find some pretty big issues, right? So you have that big Atlantic piece about his alleged drinking problems, which he tried to sue over, but I believe that suit was dismissed. So when it came to the Democrats during this hearing, though, Patel's tone was decidedly hostile. I'm sure the questions were also hostile. Let's be fair here. Senator Chris Van Hollen of Maryland received the bulk of Kash Patel's ire while discussing Patel's alleged drinking problem. So let's take a look at that.
And so there have been no occasions when your security detail had difficulty waking or locating you, is that right?
Nope, it's a total farce. I don't even know where you get this stuff, but it doesn't make it credible because you say so.
I'm not saying it, Director Patel. It's been written and documented.
You are literally saying it.
No, I'm saying that these are reports, Director Patel.
No, unlike your baseless reports, the only person that was slinging margaritas in El Salvador on the taxpayer dollar with a convicted gangbanging rapist was you.
You know,
the only person that ran up a $7,000 bar tab in Washington, D.C. at the lobby bar was you. So the only individual in this room that has been drinking on taxpayer dime during the day
polygraphing
is you.
Director Patel, come on.
Okay, so Senator Chris Van Hollen, if you're going to bring the heat, you got to be ready. Okay, you know he's going to react that way, and I just think that the way. So immediately he asks the question, Kash Patel goes on the offense. You know he's going to do that, so you got to bring your A game and dominate that situation. That did not look like domination to me. And by the way, asking the FBI director whether he has a drinking problem after a massive report about that came out is a perfectly legitimate question. In fact, it's a question he needs to answer calmly and honestly, because he's the literal FBI director who has bungled previous investigations, including, by the way he behaved in the aftermath of the Charlie Kirk assassination was a disaster. I don't know, were you drunk? Did you have 2 martinis at lunch? Like, what's going on here? Legitimate question. Patel should have expected it, and he should have had an answer ready for that question, but he didn't, which shows you how
in risk tolerance for subjects connected to the current administration. Public corruption squads recalibrated their intake thresholds. The institutional culture that once treated evidence as the sole driver began adding a second calculation, whether the subject of the investigation retained the ability to influence the director's personnel decisions. That second calculation is corrosive by design. It does not need to be spoken aloud to change behavior. The legal machinery now in motion is ordinary and therefore unavoidable. A federal judge who finds that sworn statements about the existence of court orders are false possesses clear authority to set production deadlines and to refer the matter for criminal consideration. Perjury carries a 5-year exposure. Criminal contempt adds further exposure when the misrepresentation is used to avoid compliance. The loss of a law license follows as a professional consequence. None of these outcomes require special rules for the FBI director. They are the standard consequences that attach when any federal officer's testimony is shown to diverge from the court's own files. Patel's earlier confirmation commitments now sit in permanent tension with the findings. He had assured senators there would be no politicization and no retributive actions against employees. He had promised protection against political retaliation. The subsequent removal of agents who investigated the classified documents case and the later documentary confrontation over false claims about court orders form a single unbroken sequence. The sequence does not require additional commentary to become visible. The dates, the names, and the docket entries supply the narrative. Whistleblower accounts that reached the Judiciary Committee described direct communications about the need to clear personnel who had handled Trump-related investigations. When those accounts were raised in earlier hearings, the director denied knowledge of any coordinated purge. The internal records under review suggest the denial itself has become part of the problem. Knowledge of the communications is no longer the contested issue. The contested issue is the accuracy of the sworn statements offered when the communications were placed in front of a Supreme Court judge. The Epstein file dispute added a second track of institutional damage. Representing to a court that protective orders blocked production when the docket contained no such orders is not a scheduling error.
How much of a clown he really is. So, by the way, the gang-banging rapist thing that Patel is referring to is Kilmar Abrego Garcia. That name might ring a bell because we've talked about him on the show before. He was the immigrant that the Trump administration erroneously deported to a maximum security prison in El Salvador. In fact, the Trump administration's own lawyers admitted that they accidentally deported him. And then the administration tried to cover it up after the fact. So Garcia, a resident of Van Hollen's state, met with the senator while incarcerated, wrongfully incarcerated in a maximum security prison in an effort to reverse the deportation. That's why Van Hollen was there. So Van Hollen was doing the right thing. And our FBI director tried to make it seem like he was in a foreign country getting drunk with a bunch of gangbangers. Yeah, that's who Kash Patel is. Okay, so as the New York Times points out, Mr. Patel's accusation also mischaracterized, which I'm not surprised by, Abrego Garcia, who has never been convicted of a sex crime or of being part of a gang. He briefly had a restraining order against him. So the fiery exchange didn't end there. Patel erupted again when Van Hollen inquired about the use of polygraphs within the FBI to help determine who was responsible for leaking stories of Patel's behavior to the press. Take a look.
All right. I think that the fact that you're so, have you ordered polygraph tests of members of your team to determine how that story came about?
The FBI conducts polygraph tests all the time.
No, have you ordered polygraph tests for members of your team to determine who was the source of the stories that I'm asking you about?
I don't order any polygraph tests. There's an internal inspection review process for any and all leaks, especially of baseless information at the FBI, that's been in place for the last 30 years. Those processes are followed by career intelligence and agents on the ground.
So I'll take that as a yes, since you said that these were unauthorized disclosures.
Okay. The leaks are going to continue happening. How about you don't get drunk on the job? Okay, how about that? It's not that difficult. You don't have to deal with lawsuits. You don't have to threaten journalists. You don't have to make up lies about senators. Just, do what the normies do. Wait until Wednesday night when it's okay to have a beer after work. Okay? That's what normies like me do. And don't get sloshed in public anywhere. You're the FBI director. Take responsibility for your behavior and your conduct. It's that simple. People be losing their jobs out here over accurate criticism of a foreign country, and our literal FBI director is allegedly, but I believe it, getting drunk on the job. Getting drunk at a bar that all the politicians go to in DC, getting drunk at, what is it called? Poodle Dog Bar or whatever in Vegas. I'm making up that name, but I think it's similar to that. In public, like, you're the FBI director, you're getting drunk in public. What are you doing? What are you doing? Take some responsibility for your actions. But no, he could never do that. So the hearing ended with, well, both parties essentially calling each other a disgrace.
Do you know, Mr. Director?
It is a representation about the legal constraints on the Bureau's ability to respond to judicial and congressional demands. When that representation is shown to be false, the credibility of every subsequent representation the Bureau makes about its own files is diminished. Foreign partners who share intelligence with the FBI now possess an additional data point when they assess the reliability of the institution's leadership statements. Midterm campaigns have already begun incorporating the episode. Candidates who campaign on the independence of federal law enforcement now have a concrete, documented confrontation between the FBI director and a Supreme Court judge over the accuracy of sworn testimony. The personnel actions that removed investigators of the classified documents case supply the second half of the story. No invention is required. The public record is sufficient. Historical memory inside the Bureau includes earlier periods when directors faced congressional pressure or internal dissent. None of those periods featured a Supreme Court judge placing the director's sworn description of court orders next to the orders themselves and declaring the two irreconcilable. The institutional lesson that once held that the director's word in court would track the Bureau's records has been publicly revised. The revision travels through every field office and every headquarters division. Career agents who remain are adjusting in real time. Case agents working sensitive political files now document their investigative steps with an eye toward future personnel reviews that may not rest solely on the quality of the work. Supervisors counsel caution in language that never mentions the director by name, yet leaves no doubt about the source of the caution. The cumulative drag on operational tempo is measurable in slower case progression and higher thresholds for opening matters that carry political risk. The judge's method left no opening for the usual political counter-narrative. There was no raised voice, no partisan framing, no speculation about motive. There was only the side-by-side comparison of testimony and docket and the clinical statement that they did not match. That method is difficult to attack as activism. The paper either supports the sworn claim or it does not. In this instance, it did not. Production
spokesperson at the time said the move saved the government money, but the receipts have yet to be provided. Grassley joins the likes of Congressman Jamie Raskin and Senator Dick Durbin, the top Democrats on the Judiciary Committees, who wrote their own letter to Patel this week, stating that they, quote, appreciate Chairman Grassley raising these concerns. As for Patel's luxury vacations, they write, quote, your jet setting and the lack of justification for these trips are out of control. This is not the conduct of a committed and faithful public servant, especially when entrusted with ensuring the safety of almost 350 million Americans. The FBI has not responded to MS Now's request for comment. Kash Patel facing bipartisan scrutiny for his jet setting around the globe is where we start today with the reporter who broke that story, Justice and Intelligence reporter Ken Delanian. Also with us, former Assistant Special Agent in Charge at the FBI and National Security and Intelligence Analyst Michael Feinberg. And joining me at the table, law professor at Hofstra University, the author of the Substack, Who Decides, James Sample is here. Ken, rare to see Republicans questioning the conduct of anyone in this administration. Take us through your reporting.
Yeah, that's right, Alicia. And one update, the FBI did respond after the story was published. I got a detailed email from FBI spokesman Ben Williamson taking issue with the allegations in the letter from the Democrats and answering in a very detailed way the questions that Chuck Grassley was raising, which I found interesting because he provided answers that he didn't provide to us when we first asked about, for example, the BMW SUVs back in December. So about those SUVs, he now says, which he didn't say back then, that they had originally been purchased by the State Department and they were sitting idle in a warehouse, and the FBI, Kash Patel, decided to purchase them, and that the taxpayers actually saved money, $270,000 per vehicle, he claims, as compared to the armored Chevy Suburbans that they usually use to drive the FBI director around. Now, I don't have any documents that validate that claim, but that's what he's saying. And what's interesting is that Chuck Grassley, who's the Republican chairman of the Judiciary Committee, is demanding and asking for those documents. And he, unlike the Democrats, he has the leverage to get them. And it seems to be having an effect on how the FBI is responding. So Grassley's concerned about those BMWs. He also is asking a series of questions about Kash Patel's use of the FBI jet, which is essentially an executive jet. It's a private jet, the kind of jets that CEOs fly around the country on. It's a luxurious travel experience. And Kash Patel, the FBI, pointed out that he's required by policy to fly on that jet for security reasons anywhere he goes, even on personal trips. And that's true. But what the Democrats are saying is that he's obviously taking advantage of this rule to essentially attach vacations to these official trips. And we all saw in Milan when he was in the locker room after the men's hockey team won the Olympics, that was allegedly an official trip, but he had a lot of personal time there. And he claims, Kash Patel does, that he's reimbursing the government by policy for the cost of a coach fare for all of these trips, which is what the rules require. But Democrats say it's a matter of he's exploiting this, and they question whether he's actually creating official trips to sort of as an excuse to go on vacation. They're actually saying that he may have opened an office in Wellington, New Zealand, just as an excuse to go to Australia and New Zealand. Now, again, he's denying that. And they're saying that whistleblowers are telling them that when he goes on some of these trips, he's demanding that FBI personnel set up special excursions for him, including jet skiing and a helicopter tour. Again, he is denying that today through an email to us, but that's what the Democrats are hearing from whistleblowers. And I hear a lot of concerns, I have to say, inside the FBI about just what this looks like, about that they can't imagine a Robert Mueller or a Chris Wray doing this kind of thing. Even though they flew on the jet, they sometimes flew to their vacation homes. They didn't do the kinds of things that Kash Patel is doing.
Michael Feinberg, have you heard those same concerns, and what does it mean for the FBI, even just the appearance?
Deadlines remain in force. Noncompliance activates the contempt process. Referral authority for perjury remains available to the Department of Justice. Congressional committees already hold the whistleblower materials that track the same timeline. The factual foundation is fixed. The only open questions are whether prosecutors will act on the referral and whether the political system will decide that an FBI director who lost a documentary confrontation under oath can continue in the post. The agents who still report through the chain of command are watching those questions resolve. So are the analysts whose assessments can be second-guessed the moment they touch a subject with political protection. So are the state and local partners who depend on the Bureau for joint operations and shared intelligence. Credibility is not restored by press releases. It is restored by demonstrated consistency between sworn statements and the underlying records. That consistency has been publicly broken. The longer the contradiction remains open, the deeper the operational injury becomes. Each day without full production of the ordered materials is another day the Bureau functions under a cloud created by its own director's testimony. Each agent who hesitates before pursuing a lead that carries political weight is another agent whose effectiveness has been reduced. The cultural shift from evidence-driven investigation toward personal risk calculation does not reverse itself. It compounds. This episode tests whether ordinary rules of evidence and oath still apply at the highest levels of federal law enforcement. The Supreme Court judge applied those rules without exception. The response that follows will determine whether the exception is now permanent. The docket entries remain. The sworn statements remain. The gap between them remains exactly where the judge left it. Everything else is secondary to that documented gap. The public is absorbing a rare institutional moment. The director of the FBI corrected on the record by a Supreme Court judge for statements that the court's own files refused to support. The personnel actions that cleared out investigators of the former president's classified documents case form the surrounding context. The combination is self-explanatory. No additional framing is required for the sequence to register. The agents who still report to Patel are watching that calculation play out. So are the analysts whose work product can be second-guessed the moment it touches a sensitive political subject. So are the state and local partners who rely on the Bureau for joint operations. Credibility is not restored by press statements. It is restored by demonstrated fidelity to the record. When the highest court has already stated that the director's sworn account diverged from the record, the path back is steep. This episode will not remain confined to the courtroom or the Bureau's internal channels. It will travel through every midterm debate that turns on the question of whether federal law enforcement still operates under rules that apply equally. It will appear in every discussion of whether promises made at confirmation hearings still bind the officials who make them. It will shape the next set of confirmation fights for any future nominee who claims the Bureau can be insulated from political direction. The precedent is now set in the open. A Supreme Court judge examined the paper and the testimony and found them incompatible. Everything that follows will be measured against that finding. Patel's meltdown was not theatrical. It was the visible recognition that the gap between the sworn version and the documentary version had become too wide to paper over. The judge did not create the gap. The testimony and the dockets created it. The judge simply refused to pretend the gap was not there. That refusal is what produced the collapse. And that collapse is what the rest of the system now has to absorb. The longer the contradiction remains unresolved, the deeper the institutional injury grows. Every day that passes without full production of the materials the judge ordered is another day the Bureau operates under a cloud created by its own director's sworn statements. Every agent who wonders whether thorough work on a politically sensitive file carries career risk is another agent whose effectiveness is diminished. The cumulative effect is not abstract. It is operational. Cases move more slowly, risk tolerance drops. The institutional culture shifts from pursuit of evidence toward calculation of personal survival. That cultural shift is the real long-term cost. The FBI has survived scandals before because the core expectation remained that the director's word in court would match the Bureau's own records. When that expectation is publicly broken by a Supreme Court judge, the recovery requires more than new talking points. It requires a demonstration that the same standard still applies at the top. So far, that demonstration has not arrived. The deadline remains. The referral authority remains. The personnel records remain. And the gap between what was sworn and what the paper shows remains exactly where the judge left it. The country is watching a test of whether the highest levels of federal law enforcement can still be held to the ordinary rules of evidence and oath. The answer is being written in real time by the response to a Supreme Court judge's plain statement that the director's testimony did not match the court's own files. Everything else is secondary to that fact.